think it'd be worse if I had to watch it. So you never watch it? No. It's cringe. Watching yourself on video would be awful. All right, good morning, everybody. So, a couple things. Everybody hopefully saw the announcement that we're postponing the quiz from last week. Everybody good on that? All right. I just didn't get around to it, and I figured nobody would be heartbroken for having one less quiz. But if anybody wants to take exception to that, just let me know. I put up an outline last week that also could have covered the material for this week, but then I realized I sort of redid my outline, so I want you to use the one that I posted in the part 2 module for today, for this week. And where I ended last week, I left off before negligence on last week's outline. You just ignore the rest of last week's outline below from negligence on down, and we're going to replace it with the one that I posted for this week. Any questions on that? I'm sorry, I know that's a little confusing, but I didn't I just wanted to change a couple things. And then also I realized, I think it was the next class, I was asking y'all about the tort of abusive litigation was in our fact pattern, but that's not in your outline. So no wonder everybody's looking at me funny. I don't know why that's not in that outline, but I'm not going to ask you about that on the quiz. So that's my fault. So I don't want anybody to sweat on that. Sorry about that. Abusive litigation is a tort. We did talk about it. It's just not in your outline. All right. Any questions before we get started on today? None? Anybody have anything to share? Nothing? Seahawks. Why does Monday Night Football? Monday. It is late, I know. If I lived on the West Coast, I wonder how I would feel about, like all these Sunday games starting at 10 or yeah. Yeah. Yep. Who would you rather go against, Phillies or Marlins? I don't want any part of the Phillies. I don't want any part of the Phillies. If for no other reason than I just don't want to. I can't stand watching them, and it just makes me nervous. Harper and Turner make me so nervous. But it makes me feel a little bit good that the Phillies are everybody's hot pick, So yes, that's about to fail. I could see them flaming out, but we'll see. It's time to turn it on. All right, so last week we talked about tort law in general, and then we talked about intentional torts, which obviously require that the actor have intended to do whatever he or she did. This week is about unintentional torts. The name for unintentional torts, or the tort that we're studying this week, is negligence. Okay, negligence is in and of itself a tort, and it covers a wide range of things. In general, the actor who commits a tort does not intend to bring about the consequences of his or her action, or believe that anything negative is going to occur. It's just that the conduct of the actor creates a risk of certain consequences. So another way to think about negligence is carelessness, or I forgot the word I was going to use. Well, let me give you some examples. A driver operates a vehicle in a bike lane and runs over a biker. It didn't necessarily, we're assuming that the driver did not intend to run over a biker. A driver putting on makeup and hits another car because the driver is looking into the mirror while putting on makeup. The intent is not to cause a wreck. Nobody wants to get in a wreck. But the act of driving in a bike lane or putting on makeup is careless, and it creates a risk to other drivers or pedestrians. A pedestrian trips and falls on an uneven sidewalk. The person who's responsible for maintaining the sidewalk doesn't intend for anybody to get hurt. It's just that their negligence, their carelessness has created a risk for people walking down that sidewalk. Customer slips and falls in a restaurant where a drink was spilled by a waiter. Not intentional, again, won't intend for anybody to get hurt, but someone's conduct is careless enough that there's a risk to another person. One of the things we're going to talk about a little bit more in depth is that the risk that's created by someone's conduct, it has to be something that's foreseeable. Okay, we don't have a duty to guard against something that we could never have seen coming. I don't have a duty to guard against my car exploding from some defect. I can't foresee that just by driving my car down University Avenue that it's going to explode. I do have a duty, on the other hand, to keep air in the tires. It is foreseeable that if I don't keep air in the tires, that my tire may be defective and something could happen. So foreseeability is a big part of negligence. So the tort of negligence requires proof of four main elements. And we're going to get into these in more depth, but I just want to lay them out at the beginning. So it requires four elements. A duty of care. There has to be a duty that a person owes to the general public. There has to be a breach of that duty. That means that the person didn't exercise due care in the discharge of that duty. There has to be causation, meaning the person's breach of the duty of care has to be what actually caused the injury. And that seems pretty standard, but when we get into it, you'll see it's not as straightforward as you might think. And then there have to be damages. Something has to actually have happened. If I am not paying attention, if I'm looking at my phone walking down the hall and not looking where I'm going, and I run into Yulia, but she's not injured, she doesn't drop anything, none of her property, then did I have a duty of care to be careful when I'm walking down the hall? Yeah, we all do. We have a duty not to cause harm to others. Did I breach that duty by looking at my phone instead of looking where I'm going? Yeah. Did my looking at my phone cause me to run into her? Sure, we got causation, but she doesn't have any damages. You got to have that too. She's not going to succeed at suing me for negligence if she has nothing to be compensated for, right? So there has to be damages. So those are the four elements we're going to delve into a little more deeply. So let's start with the first element of negligence, the duty of care and its breach. So really 1 and 2. Another definition here, negligence involves the careless performance of a legally required duty or the failure to perform a legally required act. Failure to exercise due care is negligence. That's really the essence of it. Failure to exercise due care is negligence. Another way of saying that is being careless is negligence. Why do we have negligence in such a broadly defined way? We don't have a law on the books that says you must walk down the hallway carefully. There's not a law on the books that says that I have to go and look and see who's on the other side of that door before I open it. Okay. But at the same time, if I'm walk down the hall in a way that's dangerous, that is something that we want to be able to have a way to address if we're injured by that. Same thing if I slam that door open and somebody's on the other side and they get hurt. There might not have been a law specifically saying I can't open the door hard, but if somebody's on the other side and they get hurt by my carelessness, that is something that the law wants to allow a remedy for. So that's the idea of negligence in general. The duty is measured by reasonableness. So this is a really important part for you to get. When we say there has to be a duty of care, what is the duty of care? The duty of care is defined under the law as the amount or degree of care that a reasonable person would use under the circumstances. Reasonable care. So we would say that as in terms of walking down the hall, the degree of care that a reasonable person would use would be that of paying attention to where they're going, not being on the phone or being distracted. It doesn't mean that the person has to be as careful as possible. The reasonable person would not walk down the hall with a flashing light and something going beep beep beep. I mean, that's not what the reasonable person would do. The reasonable person will walk down the hall with their head up and their eyes open, looking to see what they're doing. So it's what the amount of care or degree of care that a reasonable person would use under the circumstances. Now, I've told you all the time in this class, we can't agree in this country on barely on what day it is, much less on what is reasonable under the circumstances. But that is the standard. I just reiterate that again to bring up the point that it does depend on, I guess, your jury, or it depends on the person. But generally speaking, we can agree on certain. I mean, we can agree on the. I would hope we can agree on the idea that everybody owes a duty of being careful to other people. Generally speaking, we can agree on that. Now, how far that goes and what actually is reasonable is certainly up to interpretation. But that is really the essence of negligence, is this duty of care, this idea that we have to exercise a level of care that a reasonable person would under the circumstances. Landowners might have a little bit higher standard of care that they owe to people who come on their land legally, not trespassers, people who are there legally. So think like CSU. What is the duty that CSU owes to students? Your outline says business firms, or could be CSU, places that have the public in, that invite persons on their premises have a duty to exercise reasonable care to protect their business invitees against foreseeable risks that the owner knew or should have known about. So businesses and schools and things where the public come, the people who own those premises or operate those premises have a duty to warn people who are coming on the property legally about any risks that are there, in addition to just owing them the general standard of care, of reasonable care. Professionals might also owe a heightened standard of care. So in my law practice, I might be held to a little bit higher standard of care than just not being careless in my work, because I'm licensed as an attorney. Same thing for an accountant or things like that. You might be held to a little bit higher standard of care in the discharge of your duties or whatever it is that you're doing as a professional. That doesn't mean that that extends outside what the profession is. So that's the duty of care. And that's the first element in any negligence. There has to have been a duty of care owed to others. Let's say that, let me give you another example. Thinking about CSU and us being invited onto the premises. It needs to be safe, right? The smoke alarms need to be working. The exit signs need to be lit up. There shouldn't be huge cracks in the sidewalk or something that would be dangerous. If somehow a glass door is broken, it would be negligent to just leave the glass lying around and not clean it up. Those are all standard duty of care. But CSU doesn't owe us a duty of care to protect us from an airplane crashing into CCT. That's not foreseeable. It's not foreseeable that by running a college where people come to class that an airplane's going to crash into this. They don't owe that duty of care. So again, that's how foreseeability kind of comes in. So let's move on to causation then. In causation, we're going to think about two ways. So when we talked about this generally a minute ago, the breach of duty, assuming there is a breach of duty, it must actually cause the harm for which recovery is sought. That's basic. We get that. If somebody's careless and an injury results to somebody else, there has to be a causal link in there in order for somebody to be liable for negligence. There are a couple of kinds of causation. and both are required in negligence. Both of them are. One is actual cause. Actual cause is pretty basic. But for the action, the injury would not have occurred. If I had not run through the red light, I would not have T-boned Dez's car. Was my running the red light the actual cause of his car getting T-boned? Yes. But for me running the red light, he wouldn't have had his car run into by mine. Actual cause. Where we get into, well, I'm going to leave it there. You got to have actual cause, but you also have to have something called proximate cause. So negligence requires both of these kind of causes. What's the difference in them? The difference is this. Take actual cause for a second. If I had not run the red light, I would not have hit Dez's car. If I had not been running late this morning, I might not have run the red light and hit Dez's car. Me running late might also be the actual cause. If I didn't have a driver's license, I wouldn't have run a red light and hit Dez's car. Me having a driver's license is way down the line an actual cause of me running into Dez. I could take that all the way back to me being born. But for me being born, I would not have hit Dez's car 51 years later. Okay? So actual cause can go back as far as we want it to. We can butterfly effect, we can link it as long as we want to. So the idea of proximate cause comes in to say that, you know what? At some point, we're going to draw a line to where an actual cause was not strong enough or close enough or connected enough to impose liability. So somewhere along the line, we're going to draw a line that said, you know what? Everything before here was not the proximate cause. It might have been an actual cause, but it wasn't the proximate cause. And everything from this point forward was proximate cause. Can Dez sue my mother for giving birth to me? I mean, it was, if you want to be technical about it, was the actual cause of his car accident way down the line. But it's not proximate enough to the injury to where we would say she should be liable for it. If my wife wouldn't stop talking to me this morning and reminding me of all these things that I need to do today, I wouldn't have been late, and then I wouldn't have been in a hurry, and then I wouldn't have run the red light and hit Dez. I could make the argument that her keeping me late this morning was an actual cause of the injury. Do we feel like she should be liable for Dez's injury? No. I mean, it might have been the actual cause, but it's not the proximate cause. Proximate cause comes in somewhere probably when I start operating my vehicle in an unsafe way. Then maybe so. So proximate cause is another way of saying we think that the actual cause was close enough in time or proximity or cause or connection, I should say, to the injury that that person should be liable. In some ways, it's a policy question. Is the connection strong enough to justify imposing liability? So you got to have both things. You got to have actual cause and proximate cause in order to make out that element of proof. And this is where foreseeability comes in too. It would be unfair to impose liability on my mother for me 51 years later running into Dez. It would be unfair to impose liability on my wife for talking to me this morning in a way that made me late. She'd kill me if she heard me saying all this. But it's not unfair to hold me liable for rushing and driving in an unsafe way. Okay? So sometimes we can just, all this is to say we can have a long chain of events and something might be the actual cause, but it might not be the proximate cause. And it needs to be both in order to find liability. Was it foreseeable when my mother gave birth to me that I might run into Des 51 years later because I was running late to class? No. Was it foreseeable? Should my wife have foreseen that by reminding me to do things this morning, I might hurry and run a red light and run into Des? No. Is it foreseeable that me rushing to class because I'm late, that I might be operating my car unsafely? It's foreseeable. I'm not saying it's probable or definite. It's just, was it foreseeable? Yeah, it's foreseeable that if we're rushing in our car, we might have a wreck. So foreseeability is the key there too. And then the injury requirement is the fourth element of negligence. Of course, without an injury, there's nothing to recover. And in tort law, remember, one of the main drivers is allowing a person who's been injured a remedy to recover from the person who caused the damages. So without the damages, you really don't have a case. It could be in very limited circumstances that a person doesn't have any injury, but the behavior was so bad that a court might impose punitive damages on the person who was careless. I can't really think of a great example of that. Maybe I keep thinking of things that are illegal or that are crimes. Maybe I operate. I detonate dynamite on my farm, and no one's injured, but somebody's going to sue me for negligence because that's grossly, that's behavior that we want to discourage, and the court might want to punish me for that, even though nobody got hurt. I don't know. It's possible. Okay. Most states have what are called Good Samaritan statutes. So I'm moving on a little bit from the definition of negligence. Most states, anybody ever heard of a Good Samaritan statute? JJ, you have any experience with it or just heard of it? Okay, yeah. That means that if you help somebody who's in distress in an emergency situation and you go about it in a way that harms them, you're negligent, then you can't be liable for helping them. Now this protects you from negligence. Not like, it doesn't mean you could see somebody in distress that you help and you deliberately hurt them. That's intent. That would put us over an intentional towards. Negligence, remember, everything this week, everything to do with negligence is unintentional. I stop to give CPR to somebody and I do my best, but I end up pressing too hard and crack a rib. I can't be sued for negligently administering CPR because I was doing it to help somebody in distress. We got a case for Thursday that we're going to read that involves the Georgia Good Samaritan statute. So it's an actual scenario that happened here in Georgia. We're going to read and talk about that on Thursday. All right, defenses to negligence. So by the time we get to the defenses portion of any discussion, we think of it as if all the elements for that tort have been met. So we're assuming that those four things that we've talked about up to this point this morning have all been met, or the plaintiff could make out a case for those things. What defenses might somebody have against the negligence case? One is assumption of risk. This defense requires that the injured person knew and appreciated the risk and voluntarily assumed it. It doesn't have to necessarily be expressly acknowledged or assumed. It could be implied by conduct. Let's say that I operate a ski resort and a blizzard comes up and visibility is 0, and a skier decides to ski in that anyway. They might be assuming the risk of whatever danger comes to them because they can't see. When we go to before they started putting up netting at baseball stadiums, the back of your ticket used to say, your paper ticket used to say, you assume the risk of getting hit by a fly ball or a bat that's thrown in the stands or something like that. Assumption of risk. There are some things that just by doing them, I'm assuming the risk of, because I know them and appreciate them. That might be a defense. Yeah, I was negligent, but they knew about the defect. I'm say defective. That gets us into product liability. They knew that there was a danger, and they did it anyway. Yes, I have a duty to shut down my ski slope when there's no visibility, and yes, maybe I've got a duty to stop the chairlifts from operating. And I was negligent in not doing that. But also, this person should have known better, or did know better. That's assumption of risk. Superseding cause is a defense. So if a superseding or intervening force breaks the connection between a wrongful act and an injury, let's say that I was negligent in running a red light and I was going to T-bone Dez's car, but right before I T-boned Dez's car, another car ran a stop sign from a different direction and T-boned him first, and I missed him. Did I have a duty of care to operate my car safely and not run red lights? Yeah. Did I breach that duty? Yeah. Was I the cause of Dez's injury? Probably not. So maybe I don't have a negligence case there. But superseding cause is when something else comes in and that becomes the real cause of the injury. So in other words, you can't sue me for negligence. You can sue the other dude for negligence. That might be my defense. Contributory negligence. So these two defenses that I'm talking about next, contributory negligence and comparative negligence. I do want you to know the difference between those. They're related somewhat. In both defenses, the plaintiff, the person who's suing for negligence, was also negligent in some way. So both the plaintiff and the defendant were negligent. All right. Contributory negligence is very punitive. It's harsh. It says that if the plaintiff failed to exercise reasonable care, if the plaintiff was negligent in whatever they were doing, even if the defendant was negligent, then it's a complete defense. If the plaintiff was 1%, 2% at fault for what happened, they can't sue defendant. It's a total defense for the defendant. Let's say that I'm driving down University Avenue and I run a red light and I T-bone Dez. It turns out Dez was driving blindfolded. That's negligent. Okay? We're both negligent. His negligence really didn't cause me to T-bone him. It was from me running the red light. But I might, if I'm in a state that recognizes contributory negligence, I might get off completely if I can show that he was negligent too. He was somewhat at fault. Maybe if he hadn't been blindfolded, he could have seen me coming and gotten out of the way or something. Maybe that was how he's a little bit at fault. That's contributory negligence. That's the minority position among states. This is a state-to-state thing. Most states have comparative negligence. And that is the same general premise that both parties were negligent. But in a comparative negligence state, the jury or the judge decides what percentage each was at fault, and then it reduces the award by that. It'll apportion the award by the percentage of fault. So let's say that Dez sues me for negligence, and we go to trial, and the jury says Tebow was 80% at fault because he ran the red light. Dez was 20% at fault because he was driving blindfolded. We're awarding Dez $1 million in damages. It'll get reduced by the 20% fault that the jury apportioned him. That makes sense. That's comparative negligence. If you're a defendant, you'd rather be in which kind of state? Contributory or comparative? Contributory, yeah, because I might get you off completely. If you're a plaintiff, you'd rather be in a comparative negligence state. Some states kind of make it a little bit of a hybrid, and they'll say if the plaintiff is over 50% at fault, then they can't recover from defendant. So if maybe the jury decided that Dez was 51% at fault or higher for driving blindfolded and I was 49 or lower, then that might be a complete defense for me. I'm not sure which one, Georgia. I think Georgia is just a comparative negligence state without the 50% part is what I think for sure. I'll check on that and let y'all know. But that's a good question. If I put the same case in front of 3 different juries, I would wager that the juries are going to come up with different percentages of fault. I mean, that's just how our system works. But it is subjective in that sense. All right, so I want you to kind of clear your mind for a second of intentional torts and unintentional torts negligence. Forget intent for a minute at all. Forget carelessness. Forget fault. There is a theory under tort law that sometimes a person can be liable for the consequences of their actions, even if they were as careful as they possibly could be. They were not negligent, and they did not intend for any harm to occur. So their actions could not be actionable under any intentional tort, and they could not be sued for negligence. No intent, no fault. A person could still be held liable for some torts regardless of intent or fault. This idea is called strict liability. You're liable no matter how careful you were. It's another way of putting it. This is a pretty narrow slice of tort law, but it does exist. So what's an example of where strict liability might apply? Abnormally dangerous activities is one, like detonating explosives. I might be on a construction site and I have got to detonate some rock as part of the site prep, and I use explosives, and I'm as careful as I can. I take every precaution that there is. And of course, I don't intend for my detonation to cause any harm, but as a result of me detonating the explosives, the person next door's windows are broken. They could sue me under the theory of strict liability, meaning it doesn't matter how careful you were. Your actions are so dangerous that you should be liable for whatever injury is caused from it. Again, it's a pretty narrow slice of tort law, but there are certain things that and the theory kind of behind that is certain things are so dangerous that there's really no way to do them carefully. Dynamite would be one of them. Another example of strict liability is if somebody keeps lions as a pet. It doesn't matter how careful you were in pinning up your lions or whatever you did in your backyard lion cage. If your lions end up harming somebody, you might be sued under the theory of strict liability. Again, meaning it doesn't matter how careful you were. And again, this is just for things that are so dangerous that there's really no way to do them carefully. Strict liability also can apply in some product liability cases, but I want to save getting into that because we're going to talk about products liability here in a second. Any questions about anything so far? So let me just recap again. Last week was all about intentional torts. The actor intended whatever act he or she took. This week was about unintentional torts. We didn't mean for anybody to get hurt. We didn't intend for our actions to happen, but we still might be liable for any injury that occurred because we were careless. Again, if I see Des in his car and Des and I have a beef and I speed toward him and I T-bone him on purpose, that's not negligence, but it's still a tort, right? It's an intentional tort. Negligence is just for those, is for these instances and circumstances where we didn't have intent. And then we, of course, talked just now about strict liability, where it doesn't matter if anybody was at fault or if there was intent. So those are kind of the three overarching areas that we looked at tort law. And then within each of those areas, we looked at different kinds of torts and then what might be required to prove each one. And in the intentional tort section last week, each individual tort had different elements of proof. Remember, assault had to be placing someone within a fear of imminent danger, bodily harm. Battery was the intentional causing a touching or harmful contact. Trespass had entry of land, had all those different elements. Negligence just has the four elements that apply generally to any situation where somebody might have been careless. And we went through those. So that's just a very quick review of where we are up to this point. I want to spend the rest of our time today talking about product liability. And product liability is a separate area of tort law. It could be intentional. I could manufacture a product that was defective and I intend for it to be dangerous. I mean, that's pretty rare, but it's possible. Product liability could also involve negligence and very often involves negligence. Or it could be strict liability. So let's look at it under the lens of negligence for a second. Remember, every tort of negligence, no matter what set of facts you put negligence down onto, you still got to prove your four elements. So the first thing would be a duty of care. What's the duty of care of somebody who manufactures or makes a product? They've got to use reasonable care in designing the product, in selecting the materials. They've got to use reasonable care in producing it. They've got to use reasonable care in assembling it and testing it. They've got to use reasonable care in placing warnings on the product if necessary. And then they've got to use reasonable care in inspecting and testing components that they might put into the product. So at every step in the manufacturing process, from design to material sourcing to production to warning, the manufacturer has to use due care in discharging, doing all those things. It is not required to sue somebody for products liability that you actually bought the product from the manufacturer. So if Des has a chainsaw that he bought and it was defective when he bought it and he loans it to me to use and the product malfunctions and I'm injured by it, I can still sue the manufacturer even though I'm not the one who bought it from them. That's known as privity of contract. But negligence does not require privity, meaning negligence does not require me to be the actual purchaser directly from the manufacturer. So let's just think about for a second. We're applying negligence and product liability to the design of something. I think back to a case, pretty old case, but involved a Columbus lawyer. you all may not, we're probably too young to remember this, but you might have heard of it. The case where the auto manufacturer got sued because the gas tank was in a place that if there was a collision where the impact hit the gas tank, the cars were exploding. And the Columbus law firm sued, I think it was Ford, but I can't really remember exactly, on behalf of all these accident victims. And what they were alleging is negligence in the design of the product. That Ford, so that would look like this: Ford didn't use due care in designing it. They should have known it was. They should have known it was foreseeable. It should have been foreseeable to them that by placing the gas tank in that location, it would create an unreasonable risk in a collision to the people in the collision. That was a huge case, and they won a huge verdict over that. Fraudulent misrepresentation could also be a form of a product liability tort. So if the misrepresentation results in an injury, remember we were thinking of fraudulent misrepresentation last week in terms of I told you that this car had never been in a wreck, and that induced you to buy it, and it met all the other elements of fraudulent misrepresentation. Then you could sue me for that. Your damages are going to be whatever the car's worth compared to what it would have been worth if what I told you was true. That's one way that there may be a tort involved in fraudulent misrepresentation. But let's say that when I sold Dez the car, I told him that it had just been inspected and that the brakes it had brand new brakes and they'd been tested and they're in great working order. And he goes out and hits the brakes and the brakes don't work, and he rolls through a stop sign and gets T-boned. He could sue me for, well, I'm not the manufacturer, so that's actually not a good. Let's say that he bought the car from a dealership and the dealer represented that the brakes were fine. Then he might have a product liability case against the dealership under the idea of fraudulent misrepresentation. This is not a different tort than we talked about last week. It's the same elements. We're just thinking of it now in terms of the misrepresentation being about the safety of a product as opposed to some other material fact about the product. Okay, there is also, as I mentioned to you in products liability, this idea of strict liability. So I'm not going to ask you to know the difference of when strict liability might apply versus negligence in the area of products liability. But I do want you to know that there is this idea that in products liability, sometimes we would just, from a public policy standpoint, we would just rather the manufacturer be liable for a defective product, even if there was no negligence and even if there was no intent. So let's say that chainsaw was defective, but there was nothing that the manufacturer did in the design, manufacturer, sourcing, testing, warning. They didn't do anything wrong. But it turns out that it's defective somehow. I might be able to sue the manufacturer under this idea of strict liability, meaning I don't have to prove that they were at fault. I don't have to prove that they were negligent. And the reason that we have this remedy available in some products liability cases is that from a public policy standpoint, we would just rather the consumers be protected against the manufacturers regardless of fault, because for several reasons. Manufacturers, they're really in the best position to bear the cost of the injury because they presumably are a business with deep pockets or have profits or insurance in ways that they can pay, versus the consumer is more often than not in a good position to bear the cost of the loss. So, I mean, again, think about it like this. I'm injured by the chainsaw. Um, I have an injury. I mean, I have damages, right? But if I can't prove that the manufacturer was negligent or had intent, then I'm just stuck with it. And strict liability allows us to shift the burden of paying for that injury or those damages to the employer, the manufacturer, just kind of as a public policy idea. They're in a better position to be careful. They've got resources. They have testing departments and research departments and safety departments and legal departments looking at warnings and all that kind of thing. And we'd rather just make in a situation where there's no fault or negligence, we just would rather the manufacturer bear the burden of it rather than the individual consumer. That's kind of the idea behind strict liability in the product's liability context. Your outline talks a little bit about the requirements for strict liability in products cases. Not going to get too deep into this because it's kind of self-explanatory, but also because I'm not going to ask you to be familiar with this particular part of the outline in this much depth. I want to get to the next page, item 3, where it says product defects. And it talks about how products liability categorizes product defects into kind of 3 types. You could have a manufacturing defect, a design defect, inadequate warnings. I talked about some other ways that a manufacturer might be liable for negligence of in the sourcing of materials or in the in some other ways, but most cases come up under one of these 3 things: manufacturing, design, or inadequate warnings. Manufacturing defects are pretty straightforward. I mean, there was just something wrong with the way that this chainsaw, or to use an example, was made. It was the way that they installed a safety mechanism doesn't work all the time. It's just defective or faulty. And that's from it was manufactured that way. It could have been that the safety mechanism was designed in a way that was faulty. You might have a design defect. Inadequate warnings are interesting to me from a legal standpoint because we've all seen warnings and you're like, who the hell needs to be warned against this? I mean, y'all have all seen those, right? Something like, I'm making this up, but like on a pillow, like, do not eat this pillow. Like nobody's going to eat a pillow. But yet, why is that warning on there? Because some idiot somewhere tried to eat the pillow. I guarantee you they got sued on it. But when it comes to warnings, this whole negligence standard really comes in. What duty does a manufacturer have to warn users against? Foreseeable risks, okay? A pillow. Do not put this over somebody's face. Do not light it on fire. I don't know. What are the foreseeable risks that a pillow manufacturer needs to worry about? It does not, you don't have a duty to warn consumers against something that's unforeseeable, right? Or otherwise we couldn't make out a negligence case. I think that manufacturers probably go a little overboard in their warnings. And why not? It better safe than sorry is the saying. They might as well just put the warning on there and at least somebody can't sue us for it. Caleb. Would recalls cover a manufacturer? Recalls that could be a defense to a manufacturer if they put the recall notice out and the person got it and then the person didn't take it in for the replacement or whatever it was that the recall needed to do. Up until the recall, that doesn't cover the manufacturer. Obviously, could be liable for products liability if something was wrong. Um, I think that the consumers are, this is a great question. The question is, what's the consumer's responsibility to know it's out there? I don't think so. I think that the consumer's responsibility doesn't kick in until it has notice of it. And I can foresee some trouble about that because what if I moved and I didn't get the recall notice in the mail? How am I supposed to know that it was under recall? Maybe they could argue, I don't know this, I'm just thinking this off the top of my head. Maybe they could argue that if I had my car serviced, that I've got a duty to have it serviced. And at those service checkups, then that would come up. I don't know. I mean, I'd have a hard time. I'd have a hard time if somebody told me that I had a duty because I was supposed to go get it serviced, my car serviced at the Ford dealership rather than anywhere else that I wanted to. Maybe there's not a Ford dealer. I don't know that that would work either. That's a great question, Kayla. I might look into that a little bit farther. If I do get that notice though, and they can show that I got the notice, then I've got a duty of care to take it in to have it seen about, right? It could be negligent of me to know that there's something wrong with my car and then not go get it fixed. Then the negligence might flip around from them to me. Recall is a great question when it comes to products liability. All right, let's talk about some defenses to products liability. There are, some of them are the same as what we talked about a second ago, but assumption of risk. Let's say that chainsaw that I borrowed from Des is there's a safety mechanism that's missing, and it's missing because it fell off because it was negligently manufactured, but I use it anyway. Then the chainsaw manufacturer in court might say, well, yeah, it was defective, but he knew it was defective and he used it anyway. So he assumed the risk of using a defective product. That would require them to prove that I knew it, which would be hard to do, but if something's really obvious, then it might not be that hard to prove. Could depend. But assumption of risk could be a defense to product liability. Similarly, product misuse could be a defense that the manufacturer might use. Maybe someone used a product for something for which it was not designed. I used the chainsaw as a bottle opener to open my Cold Coors Light on Friday night, and it shatters the glass, which flies up and hits me in the eye. I've misused that product. Now, you can always also make an argument that, and some courts will say that if the misuse was foreseeable, then the manufacturer should put a warning on there, don't use it in this way. That's, we could go down that road for a long time, I suppose. But product misuse is certainly a defense that a manufacturer might use. Comparative negligence and contributory negligence, those might also both apply as a defense in products liability, much like they did in general negligence. And then if there's a commonly known danger, that a knife is sharp, that a chainsaw could cut a limb off, a bodily limb off, no pun intended, that might be a defense. Although that to me gets kind of murky when we might think about warnings or things like that. So for where we're going from here is on Thursday, we're going to talk about, I've got a case for you to read. It's not very long. A Georgia case on, what I say the case is? Oh, the Good Samaritan statute. Then I've got a fact pattern that we can read it in class. It's a short paragraph, it's not long. And we're going to discuss it much in the same way that we did last Thursday on those intentional torts fact pattern. This fact pattern is on negligence. So we're going to go through that together. And then we're going to look at a famous products liability case, which is the McDonald's coffee case. So before, has anybody read what I posted on that yet? I mean, I didn't think you would. I was hoping you wouldn't have. Who has ever heard of this case? Has anybody not heard of it? Not sure? Okay. Jesse, you heard of it? The McDonald's coffee case? Don't look it up. You said you'd heard of it, Yulia. Yeah, it's a really old case. And what happened was the lady was riding shotgun through a McDonald's drive-through. Her nephew, I think, was driving. And she got a cup of coffee and she put it between her legs. And she was going to put whatever she was going to add to her coffee. And the top came off of it and it was between her legs and it squeezed and the coffee spilled out kind of into her groin area. And she was wearing sweatpants and it essentially melted it into her skin. And she ended up going to the emergency room and having all these skin grafts and surgery and things like that. And she sued McDonald's for it under the theory of products liability, that they had served coffee that was too hot for consumption or that was dangerous. And it went to trial and the jury awarded her like $3 million or something. So this case didn't hit the news until the jury award. And the way it hit the news was, what is this country coming to? What is going on? This lady has, we just sue, this country will sue for anything. This is nuts. And so she got all kind of negative press, and it just sort of it went viral before viral was a thing. I mean, it was on all the nightly news cycles and all the newspapers. 80s, yeah, I was going to say early 80s. Yeah. Is that right? Oh, I thought you said 84. Okay, so early 90s. Okay. Gosh, I was thinking it was older than that, but wow, so it must have actually happened early 90s. But that's a little preface into how I want you to approach this. I think when you read it, and a lot of our discussion Thursday is going to be about how the press that it got was not necessarily the full story. And there were some pretty good reasons why she sued and why the jury ended up giving her that huge award. So that case is what I've assigned for you for that case is more a newspaper article about it and some facts about it. It's not like an actual court opinion. So it's written in a little bit more interesting and easier to read way. But that sets the stage for Thursday. So we'll have plenty to talk about on Thursday. And then remember, you have a quiz due next Monday that covers this week and last week. You have a discussion question from last week, but not one for this week. So if you didn't do last week's yet, go ahead and make sure you do that. Remember, your discussion questions, I don't grade them that week. I wait till the end of the semester and make sure I read them every week, but I wait till the end of the semester to go back and give the grades. Discussion questions are one assignment grade all lumped together. If there's 10 discussion questions and you do 9 of them, you get a 90. You do 10 of them, you get 100. You do 3 of them, you get a 30. This is an easy 100 assignment grade that you should get. Don't wait till the end. If there's 1 or 2 that you've skipped over, hadn't done, you can go back and do them. I think that's all that I've got for this week. Any questions for today, Des? Do I know anybody who makes a living off of filing lawsuits? Yeah, I know several. There are some lawyers that practice what they call plaintiff's law, or they're plaintiff's lawyers. And you don't have to be a plaintiff's lawyer or a defendant's lawyer. You can mix, but most plaintiff's lawyers just sue people. So like my very best friend he sues doctors. He's a plaintiff's lawyer for medical malpractice. That's all he does. That's all he's ever done. That's how he makes his living. There are like the Morgan and Morgan, and all the people that who have the commercials on the Braves games, and Wheel of Fortune, and all that other old people shows that I watch. Those are mostly plaintiff's lawyers, and they make their living suing other people. So yeah, again, you don't have to specialize that way, but most people gravitate that way one way or another. If somebody wanted to sue doctors, but also defend doctors, they're not going to do great business, because most doctors don't want to be defended by somebody who sues doctors at the same. I mean, it's just a little bit of a conflict. It involves insurance companies, and anyway, you kind of do have to pick a side if you're going to do it that way. But yeah. Any other questions? All right. Well, if that's all, then let's quit a little early this morning, and I'll see y'all on Thursday.